Proceed. Very well. This is a time set for oral argument in our case number IC220035, JTSG Enterprises Inc. Solutions Staffing et al. Versus Carlos Martinez. Each side is allocated 20 minutes for oral argument. Appellant, or petitioner, I should say, you're free to reserve a portion of that time for rebuttal if you wish to do so, but if you want to do so, you need to keep track of your own time at the podium clock. I will ask those in attendance to avoid embarrassment and interruption, to make sure your phones are off so our proceedings are not interrupted. We've read the briefs, we've conferenced the case. We are familiar with the record. We'd encourage you to keep that in mind as you present argument today. Our proceedings are being recorded, and we would ask that you make as you present your arguments, you start by telling us your name and the party that you represent. With that, Mr. Baker.
Hello, Steve Baker for petitioners, Solution Staffing, and Zurich American. And if I could, I'd like to reserve 5 minutes in rebuttal.
It's your clock,
my
so
money,
yes.
Yeah, I know. So I'd like to start off by saying that I think we can decide this case here today without statutory constructions, reaching constitutional issues, and I think we have an obligation to do that if we can. I think we can decide this issue on fairly straightforward workers' compensation principles involving loss of earning capacity. So once you're injured, once you have work restrictions, we have to make a determination as to whether or not you're owed money as a part of your loss of earning capacity as a result of your industrial injury. And there are certain presumptions that arise. Post-injury earnings are presumed to establish your earning capacity. But what happens when you're in a temporary disability status? These aren't permanent work restrictions. And the job you've returned to after your injury comes to an end. Can you use those post-injury earnings to set the LEC or loss of earning capacity benefits, or can't you? And that was a debate that raged for years in the workers' compensation world, and then the legislature stepped in and told us what to do. And that's at 23-1044D. If the employee is unable to return to work or continue working in any employment after the injury due to the employee's termination from employment for reasons that are unrelated to the industrial injury, the commission may consider the wages that the employee could have earned from that employment as representative of the employee's earning capacity. So I think a mistake that's being made, and I think the judges would appreciate it if you all would give us some instruction in this area. The issue of misconduct, were you terminated for a good reason, were you terminated for a bad reason, isn't relevant. The issue is were you terminated for reasons as related to your industrial injury or not? So in Judge Morgan's decision, Judge Morgan's a very good judge, very knowledgeable, a lot of respect for her, but I think she didn't limit herself to the correct question. She went beyond that and found that this individual had been wrongfully terminated, and then without analyzing whether or not he had a loss of earning capacity as a result of that termination, simply found that he was entitled to temporary disability benefits because he had been wrongfully terminated. Wrongful termination is irrelevant. The only issue is, was he terminated for reasons related to his industrial injury? No one argued he was. The judge didn't find he was. What the judge found is that he was terminated because he had a positive metabolite and that his termination was in violation of the Arizona Medical Marijuana Act. And the interplay between the Arizona Medical Marijuana Act and the Drug Testing Act, it's convoluted, it's confusing, and we don't need to go there. So here's what I think should have happened. Okay, so he had post-injury earnings. Those are presumptive of his earning capacity. He was let go. He was let go for reasons unrelated to his industrial injury. So therefore, he has to show that he does have a loss of earning capacity. How does he show that? He could have retained a vocational expert to do a labor market survey and say, here's his work restrictions. Can we find him work? Can't we? If we can, is there a loss? Isn't there a loss? He could have argued he was odd lot. That doesn't work in this case. Zimmerman says odd lot is really disabled. In Zimmerman, the guy had rheumatoid arthritis. industrial injury aggravated the rheumatoid arthritis. He had to lay on a couch 2 hours out of the day. He couldn't walk, sit, or stand for any length of time. A person that disabled doesn't have to engage in overcoming the presumption. They don't have an earning capacity. They're in an odd lot. He could have conceded a residual earning capacity, 40 hours a week, in this case 35 because he worked 35 hours a week at minimum wage. He could have conceded that and we would have had to pay him money. Or he could have showed that he engaged in a good faith job search, and the judge didn't really address that. She didn't address whether or not that was in fact a good faith job search. If you read her decision, specifically in the decision, she says, I can find it here, I find that but for defendants terminating him from employment, he would have been able to continue in a light-duty position as accommodated by the defendant employer, and that such work was within his medical restrictions and was readily available to him. But she doesn't say, well, okay, he's terminated. Now does he have a loss? Has he met his burden of proof? How did he meet his burden of proof? He tried to show that he engaged in a good faith job search. But she didn't analyze really whether or not that good faith job search was anything more than a token effort at finding work. So we know from the case law that simply, for example, applying, signing up at the union hall, signing up at an employment office isn't enough. Not engaging in in-person solicitations isn't enough. You have to look for work that you can do. So what was the work he returned to? He returned to work as an office clerk, essentially. Did he look for office clerk work? We know he can do office clerk work. He did it. So did he look for office clerk work? He did not. So what did he look for? A driving instructor. He's got a broken right foot, and according to his testimony, he's on crutches up until the day he's discharged from care. It doesn't sound likely that someone on crutches with a broken right foot is going to be a qualified driving instructor. The judge didn't address that. He applied for a job as a driver. Again, 35, 40 hours a week working as a driver with a broken right foot and on crutches. The judge didn't address that. Benefits specialist. What qualifications did he have to be a benefits specialist? He didn't discuss any of his qualifications. Cable installer. If he showed up at my office to install cable with a broken right foot and on crutches carrying a toolbox, I'd have doubts as to whether or not I'd let him install cable in my office. Cable technician, same thing. How's he going to install cable on one leg? Car salesman. He didn't discuss what qualifications he had to be a car salesman. Greeter. Okay. He could be a greeter. One job for 3 months that he might have been qualified to do, that's not a good faith job search. That's just a token effort.
On that issue and that determination, what deference do we owe the ALJ's determination, which seemed to me at least to be based on credibility?
Okay, so he says he applied for those jobs. She accepts the fact that he applied for those jobs, but the analysis ends there. So she has to, under Post versus Industrial Commission and Aguirre, both Arizona Supreme Court cases, her decision must be set aside if it fails to make findings on all material issues. Material issue, did he engage in a good faith job search? He's credible. Yes, these are the jobs he looked for. Are those jobs he can do? She didn't make a decision on that. I don't think he can do any of those jobs reasonably.
Even greeter?
One job in 3 months, I think that's nothing more than a token effort. And I think D'Amico stands for that proposition that's not a good faith job search. If I'm looking for a job in good faith, I'm applying every day, I'm on the internet, I'm looking, I'm calling up employers, I'm following up. There was no follow-up. None of the people he applied for work with did he ever call back. There was no evidence he called any of these people back. So as a matter of law, that simply isn't sufficient.
So your position is the positions that he testified or provided evidence that he applied for, that was inadequate as a matter of law for the ALJ to reach the determination that he made a good faith attempt to secure employment?
Because it has to be good faith, it has to be more than just a token. If you look at Zimmerman...
And I understand that. It's just every time I see good faith, that to me suggests sort of a facty kind of issue where deference is owed.
Facty kind of issue with deference, but still there has to be some sort of objective standard that we can rely on and looking at and saying, okay, is it good faith to apply for just one job that I can do? I mean, just from a common sense standpoint, unemployment requires four job searches a week at a minimum. That seems to be a fairly accepted standard in the community. I don't think that you can give deference. For example, let's say that he engaged in no job search activities, and the judge says, well, I think that's good enough. Well, then he'd have to be odd lot.
And I understand that, but that's where the slippery slope begins, right? That's the most extreme, and we, even from your perspective, we don't have that record here.
That he engaged in zero?
Zero.
But he may as well have. I mean, if you...
Well, but you're beginning on the sled down the snow-filled hill when you do that.
I don't think so, because, for example, in Zimmerman, in finding that the individual was odd lot, the court admitted that his job search activities in the small town he went to, which were about equal to what this individual did, his job search activities were, as the court said, questionable. But we don't need to go there because he's odd lot. So we need some guidance then, because I think the court needs to say, this is or this is not. And I couldn't find a case that really kind of comes up with, and workers' comp is a lot of bright lines. We're not very bright, so we need a lot of bright lines.
But Mr. Bigger, I mean, isn't that what the ALJ did? The ALJ made a determination that what he did was enough.
But I guess I'm struggling with what's the guidance then. If I'm advising my clients, what's enough? If I'm arguing to a judge, what's enough? Can you all tell us what's enough? Can you give us a baseline? This is clearly not enough. This is too much. I mean, this guy is limited to sedentary work. I understand that. We're talking about clerical work. He didn't apply for any clerical jobs. He didn't apply for any cashier jobs. He didn't apply for anything that the very minuscule record shows he was capable of doing.
So what rule would you like us to impose
Sure.
then? I think you're asking us to impose some bright line rule so that litigants can understand. But what would you propose that should be doing? And I'll just say, I mean, you talked about the good faith job search in your briefing, but a lot of it was focused on the conflicts between the law, whether he was a qualifying patient, and I want to make sure I'm understanding. You're saying that none of that is an issue we should address.
In looking back on this, I think that the judge and I think myself stepped into the trap. The trap is addressing things you think matter that don't. And that comes from not going back and looking at the underlying statute and what it says. Because we've all got, I'm sorry.
So I just want to be clear. So what you're asking, contrary to what the briefs say, what you're asking us to address based on your argument today is really just about the qualification for workers' comp, not all of the issues about his marijuana card and whether he was a qualifying patient, whether there was a safety-sensitive issue there. You don't want us to address any of that.
I don't think you need to. And that was always my alternative argument, not articulated as well as it should have been. But I argued throughout there that she'd erred by not going on to the presumption. I don't think you can sustain her decision because she didn't address what you're asking me to address now. What's the standard? How did she find that this was a good faith job search when all but one of the jobs he wasn't qualified to do?
Well, and I think that we're not asking, she didn't address it, and we're only asking you to address it because you brought it up. And you're asking us to give a bright line rule. So that's why I'm asking what it should be.
Okay. First of all, the judge is obligated to analyze that issue under Post and McGuire. So what I would say is I would use this case as an example. And I would say that one, the judge has to analyze whether or not these are jobs he's qualified to do. And two, if so, is the number of applications he engaged in sufficient to show that he made a good faith effort to find work as opposed to a token effort? And so when I look at, and again, I'm arguing what I've already said, but when I look at these jobs, if I was a judge, what I think I would do is I would say, okay, could he be a driving instructor? Could he be a driver? 80% sedentary, on crutches, broken foot, benefit specialist, what's his qualifications? Cable installer, cable technician, car salesman, greeter. I think there's only one job that he's even qualified for. I would say.
Well, counsel, what if the claimant has a different view of what he's qualified for? And people look at me, I can't imagine I drive a car, and none of my feet work very well. So how is the judge going to, oh, you're not qualified for that job, if he truly thinks he is?
I think what I would do is I would suggest an objective standard, and I would say, okay, given your work restrictions, can you actually do this kind of job? And we give the judges a lot of leeway on these loss of earning capacity determinations to apply some common sense. So could he realistically do work as a driving instructor? Could he realistically be a benefit specialist? And I would say that under Post and Aguirre, the analysis has to include an analysis as to whether or not he can really do this job. Is this more than a token effort? Is this actually a good faith effort to find work?
Well, I guess my question is, the ALJ is trained to decide legal issues and make factual findings. The ALJ is not supposed to be all-knowing about what any particular job requires.
But that's what we're supposed to do. We're supposed to give the judge that information. So if I'm representing an applicant, I'm going to say, okay, did you complete high school? What's your work experience? What kind of work have you done in the past? Have you been an office clerk? Yes, I've been an office clerk. What's your experience? What kind of office clerk jobs did you apply for? I think those are the things you need to explore in order to show good faith. I think simply signing a piece of paper that shows that I contacted these people and turned it in, I don't think that's sufficient when you have to determine whether or not the person engaged in a good faith job search.
Was it argued below that the claimant doesn't qualify? What did the judge say about that?
Yes, both at hearing, in post-hearing memo, and in the request for review. And here I've argued that he did not engage in a good faith job search under D'Amico, under Hoffman, under Schnatzmeyer. None of those cases I don't think would allow this limited activity to be sufficient to establish a good faith job search. So the burden didn't shift to the defendants to show that he didn't have a loss of earning capacity. The judge didn't address these material issues. And I think what the judge did was reverted back to the line of reasoning that was discredited in the past. What she basically said is the job's no longer available to you, therefore you have a loss of earning capacity. The statute says that's not the analysis you use any longer. The analysis is you were let go for reasons unrelated to your industrial injury. Do you have a loss of earning capacity? And keep in mind, the judge doesn't have to accept those post-injury earnings as a loss of earning capacity. She may, or he may. But if the presumption is that you post-injury earnings are indicative of your loss of earning capacity, then I, as the injured worker, have to overcome that. And he didn't do that, and the judge didn't analyze it properly. She simply assumed the job is no longer available, therefore you have a loss of earning capacity. I'll reserve 2 minutes unless there's questions.
Thank you. Ms. Watts.
May it please the court, my name is Shayna Fernandez-Watts, and I am the attorney for respondent Carlos Martinez. I'd like to start by telling you a little bit about Mr. Martinez. He is a veteran who was prescribed medical marijuana because of back pain associated with his time serving in the Army. There is no dispute that he was terminated because he tested positive for THC in his urine. I'd like to also address briefly the arguments that were brought up by petitioner. ARS 23-1044 wasn't referenced in the briefs, but I will say that it is our contention that Mr. Martinez was terminated because of his injury on the job. So I think that's a disputed issue that would need to be determined if that is really the basis for petitioner's argument. The other thing that I'd like to point out is that petitioner has argued that Mr. Martinez was not applying for jobs within his ability. The case cited by petitioner for this position, D'Amico v. ICA, is a Court of Appeals opinion about a cabinet maker. And the cabinet maker was only applying for positions as a cabinet maker. That's not what we see in this case with Mr. Martinez. And at this level, at the Court of Appeals, the court should be looking at whether or not there's enough evidence at the underlying level, whether there is a reasonable evidence to support a contrary finding of fact, with evidence viewed in light most favorable to upholding the ALJ's findings. The court is not going to be looking at whether or not there was good faith, or it's not supposed to be engaging in a fact-intensive analysis. The question is whether or not there was enough reasonable evidence, and I think that the court can conclude that there was. Because we think that the issues raised in petitioner's brief are relevant to the court's determination, we would ask that the court issue an opinion on the safety-sensitive issue and the good faith basis for determining whether or not Mr. Martinez was impaired. Petitioner contends that Mr. Martinez was terminated under the safety-sensitive exemption of the DTEA. The safety-sensitive exemption to the DTEA was added by the legislature 1 year after the AMMA. It is unconstitutional because it categorically bars medical marijuana patients from jobs without any regard for impairment. The DTEA defines safety sensitive as any job from an art therapist to a CPA. It's any job under Title 42. The amendment to the DTEA violates the AMMA by adding a category to an enumerated list of categories in the AMMA that wasn't there to begin with. The AMMA allows discrimination under two circumstances. One is if that discrimination would, or allowing the person to work at that job would cause the employer to lose benefits. And the second category under AMMA, it's 362813B2, is when the employer uses, possesses, or is impaired by marijuana at work. The DTEA adds a third category to this enumerated list and says that employers can terminate employees if they work in a safety-sensitive position, which, as I noted, is everything that council can possibly think of. It's not only safety-sensitive positions, but it's any position that the employer designates as safety-sensitive. It's any position that's in Title 42, which, as I mentioned, includes art therapists, CPAs, cosmetologists, everything. This is important because in Hermaestas, the Supreme Court says that when you have a voter initiative or a measure that is amended by the legislature, it has to further the purpose of the act. The DTEA, the safety-sensitive exemption that was added, does not do that. As a matter of fact...
Let me ask, as the case comes to us, your client received benefits, right? So, but you're arguing us that we should, so in other words, the ALJ didn't find that the safety-sensitive position exception barred, but you're asking us to address it in the first instance on appeal in response to the petition. Is that right?
Correct, because the briefing argues that the safety-sensitive position was ignored.
And I understand that, but, you know, this court gets shy when we're asked to opine on constitutional issues, I think for really good reasons. And why is this the good case to do that, as opposed to a case where an ALJ would actually apply that statute, and you would be arguing, perhaps, as petitioner, that that was unconstitutional?
What makes this case, I think, a good case for the Court of Appeals to decide is that there are limited facts. Unlike the cases that Arizona courts have already seen, Terry, decided by this court, Whitmire, Lee, and Mesas, but that's a different statute that was decided. Those cases had instances where there were other issues of impairment. There's suspected impairment on the job. This is a very clean fact scenario where we have an employee who tested positive for THC, and it's the only reason that the employer decided he needed to be terminated. And now they're arguing that they were justified in terminating him.
And I understand that, but we're in the workers' comp context as opposed to the termination of employment context. I know there's substantial overlay, but this is an IC case, not a termination of
Understood.
employment case.
Well, and you've won below. And at least as I understand the argument today, your colleague isn't taking any issue with what you're saying. They're focusing on the good faith effort to find employment, given that that's all that they're really arguing today, and the fact that your client's already won. Why should we? I mean, we have no basis to go any further.
If the argument was limited to that, Your Honor, I would agree that we wouldn't be getting into these other issues, but petitioner did make those arguments in the brief. Additionally, I would say that Mr. Martinez and many people in Arizona are looking for guidance on this issue. It is a very important issue that it's over 10 years now, and as an employment lawyer, we've discussed this issue many times and how the courts are going to apply it. Mr. Martinez does have an underlying case that was stayed while the court decides this case. And the only reason we agreed to stay that case just last month was because we thought that the court on appeal might be considering these issues and making a decision as to whether or not the safety-sensitive exemption is constitutional and was correctly applied.
Your colleague seemed to take that away from you, though.
I'm sorry?
Your colleague has seemed to take that away from
and
you.
I will admit I am excited to be here before the Court of Appeals on this issue. I think that this is an issue that needs to be decided and has been incorrectly applied for many Arizonans. And side note, Voter Protection Act is really what we're talking about here. And it's talking about when we as a legislature, when this legislature can take that power away from the Arizona citizens who have enumerated what they believe is the correct way to enforce and to protect Arizona medical marijuana card holders. So, I would ask that the court decide that issue for those reasons. Although if the court decides not to, I'm certain, on the job search and the good faith basis, I think that the court has enough to decide that issue also in respondents' favor.
But if we're addressing an issue like that, don't we have a requirement? Isn't there a requirement that the Attorney General be notified, in terms of a constitutional issue, a constitutional question? I mean, what do you say to that? How do we address this case without that happening here?
And the President Pro Tem of the Senate and the Speaker of the House. I don't think they were served from my memory of the case.
That's correct, and I would have to look into that and determine whether or not that would apply to this scenario. But if that were a requirement, then certainly the court couldn't decide the issue. I'd like to talk briefly as well about the petitioner's argument in the brief. And again, if these arguments are waived and are not relevant, then I will take my seat. But the petitioner has argued that he was entitled to terminate Mr. Martinez based on a good faith belief that because he had tested positive for THC. In Whitmire and in the statute 362814A3, that law of Arizona prohibits Mr. Martinez from being terminated based on a positive test result alone. The only way under Whitmire, the courts have said that you can terminate someone is if there is an expert opinion that has been offered saying that person has THC levels at a level sufficient to show impairment. So terminating Mr. Martinez on this basis was, as Whitmire says, a bright line disregard for the AMMA.
Can you address more fully, if you use the argument about making a good first job search?
Sure. So Mr. Martinez applied for, I believe it was 4 jobs every month. One of the jobs that he applied for was as a driver. I was not Mr. Martinez's workers' compensation attorney. However, I can tell you he also applied for a salesman. He applied as an instructor, as a greeter, as petitioners noted, and as a benefit specialist. So in the record, there isn't any evidence as to those job qualifications or whether or not an accommodation could have been made, but Mr. Martinez did testify at the hearing when asked that he was hoping he would be able to discuss accommodations with the employers if he got an interview. That's the extent of what he did, and I think the ALJ found him to be credible and believed his testimony on the issue. The other argument made, and I just want to address it to be certain and to be complete here, is petitioner did argue that Mr. Martinez was not a qualified patient. They argued that despite him being a card carrier, that he didn't establish to presumably the ALJ that he was this qualified patient entitled to the protection of the Act. So there is a process for verifying a medical marijuana card holder. And the record shows that a medical professional did do this and verified that he was a card holder. So whether Martinez was a qualified patient was actually not the reason that he was terminated. It's kind of a post-case argument that we're seeing here, and I just would like for the court to be aware of that. State v. Jones, the case cited by petitioner for this issue, that case doesn't discuss what makes someone a registered qualified patient. It's our contention that holding a valid medical marijuana card is enough, by including under the definitions of the statute themselves.
And Staffing Solutions, I think, is not taking issue with that anymore. Is that correct?
That's correct, yes. The other issue raised by petitioner is that Mr. Martinez didn't notify his employer of his card carrier status before the drug test. There's nothing in the AMMA that requires that. There's nothing in the DTEA that requires that. And again, it's one of those arguments where, petitioner admitted that they terminated him under the zero tolerance policy, not because he failed to notify them in advance, or there's no proof that that would have made any difference in this case.
This is not Terry, in other words.
Exactly, yes. And then the last argument, which I don't know that the court needs to go into, and I appreciate probably doesn't want to go into issues it doesn't have to, is the policy, the employer policy, and whether or not employer had a compliant policy under the DTEA. So the DTEA requires that in order to rely on the defense that they can't be sued for various reasons, including the safety-sensitive exemption, they have to have a compliant policy. It's our position that the policy also did not comply with those provisions because it failed to identify the substances tested, describe the testing methods and collection procedures, explain the rights of the employee on request to obtain the written test results, or explain the right of the employee to explain a confidential setting a positive test result. In this case, that could have made a difference if that policy or Mr. Martinez would have known his rights on that issue. He was simply told as he's walking into work one day, you're terminated, you tested positive for THC, to which he did tell his employer, I have a medical marijuana card, and they said, it doesn't matter. The policy simply did not comply, or even if they had a policy, they didn't follow it.
Counsel, can I want to interrupt you if you have other points on that. I understand it, but your colleague today started out with, this is an issue about, how workers' compensation cases are valued and determined, which I didn't really read in the record so much as their argument up to now. I'm just wondering if you have any comments on that argument since he did bring it up today.
Sure. So as I was writing down 231044, as I understand it, an employee is unable to return to work for reasons unrelated to his injury. So if our position is that it is related to his injury, I mean, that I think is maybe another reason for the court to get into the other issue of the safety-sensitive exemption, because I've read all of these statutes, and I can tell you that even in the definition of impairment, which was another addition to the DTA, impairment is defined as an injury at work. It's the House bill includes it is so broad that a person can be considered impaired under the DTA, and therefore they can be terminated for impairment. It goes way beyond what Arizona voters intended with the Arizona Medical Marijuana Act, and I think it's creating confusion even in how this case is being interpreted and enforced against him. So while I don't have any case sites, unfortunately, to that statute or how it's interpreted, I believe that arguing that it was unrelated to his injury is not our position.
Thank you.
I think the only other request that we had, which I did want to note because this court has found sufficient, is that in Gallardo v. State, the court did award costs and attorney's fees on appeal. So our last request is that the court consider that case and the private attorney general doctrine, which in this case, as I've mentioned, is, I believe, critical and of great societal importance. So with that, I'll take my seat unless the court has any other questions.
Thank you, Counsel.
Thank you.
Thank you. Mr. Baker.
So Judge Foster, you asked me, and I don't know if I answered your question. No, we do not believe you need to address the statute in reaching your decision today. And I know a lot of time was spent briefing it, but when you look at it, the alternative argument we've always had is that the judge simply didn't make the right decision applying the good faith job search rule. And so we don't think you need to reach the statute. If you do reach the statute, we're not waiving any of our arguments, but I think we have an obligation not to reach the statute, not reach constitutional issues if we don't need to. So what I would ask is a couple things. One, I think the judge erroneously reasoned this decision because she didn't do it pursuant to the statute. And the statute is inherent in how we decide these loss of earning capacity benefit cases. The statute simply says, did you lose your job because of the industrial injury or not? The judge went too far. The decision needs to be set aside. She found a wrongful termination. That's not relevant. The only relevant question is, was he let go for reasons unrelated to his industrial injury? Answer, yes. Okay. Then, did he establish a loss of earning capacity? She didn't analyze, nowhere in her decision did she actually analyze whether or not he engaged in a good faith job search. She simply concluded that benefits were due because he was wrongfully terminated. And I pointed this out during the hearing, and I tried to point it out in my request for review, my post-hearing memo, that regardless of whether he was terminated correctly or not, he still didn't meet his burden of proof. That's it.
Thank you, Counsel. Thank you. We appreciate your briefing. We appreciate your presentation today. We don't often have oral argument in industrial commission cases, and we appreciate the opportunity. We'll take the matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.